Good morning, everyone. My name is Victor Kane from Los Angeles, California. I'm the chair of the California Law Revision Commission. We're here for the August 13 meeting of the commission, and we are joined by commissioners and at least 10 participants by Zoom in the audience. Let me start by asking commissioners to introduce themselves, because I understand that although I can see all your names on the screen, that some of the participants will only see the speaker. So going down the list, you want to introduce yourself, Professor Carrillo?
David Carrillo, Executive Director of the California Constitution Center at Berkeley Law.
Ana Cubas?
Good morning. This is Ana Cubas from Los Angeles.
Jane?
This is Jane McAllister. I'm an attorney in Modesto, California, and that's me.
Richard Rubin?
Greetings, Richard Rubin of Marin County, sometimes called Marvelous Marin. I don't know where we got that name, but glad to be here.
Richard Simpson?
Rick Simpson. I'm a retiree from the state legislature and grew up in Marvelous Marin.
Commissioner and Legislative Counsel Diane Boyer-Vine?
I'm Diane Boyer-Vine, and I'm in Sacramento.
Brian?
Yes, the staff now. I'm Brian Hebert. I'm the executive director.
Kristen?
Kristen Burford, staff counsel with the commission.
And Barbara?
And I'm Barbara Gall. I'm the Chief Deputy Counsel of the Commission.
I think that's everyone for now. We do have a quorum. As I've announced in previous meetings, there'll be an opportunity for public audience comment. We will, when the time arrives, ask for that, and you can raise your hand with the raise hand function on the Zoom program if you wish to participate, and we will call you. If I don't see the hand raised, Brian will let me know as well. So everyone will get their turn if they want to participate. If there are no further questions, let's proceed with the agenda items. Okay, let's start with minutes of our July 9th meeting, please.
I move to adopt the minutes.
Second.
All right, any discussion or comment? I saw a hand, Richard Rubin.
No, not at all.
Oh, okay. Any comments or discussions or changes about the minutes? Okay, I see no takers on that. So all those approving the minutes, say aye and raise your hand. Aye.
Aye.
Anyone opposed? Seeing none. Any abstentions? Seeing none. Very good. Next, we turn to the report of the executive director.
Yes, there's not a lot to report that's new anyway. One issue that the chair brought up with me separately that's worth revisiting is that, we annually have a report where we talk about the various statutes that apply to the commission as a state agency and that govern our operations. One of those is the Public Records Act. And we've had discussions before about the fact that recent case law held that the Public Records Act extends to communications you may have using your own private communication services like email on a private account, so long as it relates to the commission's business. So those private communications related to the commission's business are still susceptible to public records requests. Commissioner King suggested that I remind everyone of this and point out the practice he's adopted, which isn't mandatory, but he does it for, I think, convenience and transparency, which is that he actually set up a separate Gmail account that he uses for any commission-related business. And so if we ever got a request for his commission-related email, it'd be very easy for him to collect that and send it along to me. Like I said, this isn't required by law. It's more of a possible prudential step you could take just to make the process easier. So bear that in mind. The other wrinkle I'd say is that if all of your communication regarding the commission is to someone on the commission staff using a commission governmental email account, then you wouldn't have to worry about it because we have a record of those already on our end. But if you anticipate the possibility that, you know, you might take public comment from somebody else who's not on staff, then that'd be worth thinking about. Another thing I wanted to discuss briefly that I learned just the other day was, you know, we finalized that report, I think at the last meeting, describing sunset dates that are set to operate on January 1, 2021. After we report along to the judiciary committees, we had been primarily communicating with Assembly Judiciary Committee on that issue. And they were sort of serving as our liaison to the legislature for addressing it. So I had a chance to speak to committee staff the other day, and I asked, you know, how they had addressed the sunset issue based on the information we gave them. And what Assembly Judiciary did, reportedly, is that they looked at all of the provisions in our report to see which ones were within their subject matter jurisdiction. And the ones that were within their subject matter jurisdiction, then they decided to address in their current committee omnibus bill. They couldn't simply sweep in everything because of the limits on their jurisdiction, but they did distribute copies of our report to the other subject matter policy committees so that they could look at it and decide what they wanted to do with it. So at a minimum, we know that there's maybe a dozen or so provisions that got into the Judiciary Committee's omnibus bill. I think that's AB 3364. And likely that it had greater benefit than just that as the other committees looked at it. So that's good news. It's nice to confirm that there was a positive effect from that work that we did. That's all I have for the Executive Director's report.
Thank you very much. Any questions for anybody? No? Okay, let's move on next to Commissioner suggestions.
I'm gonna we can do suggestions, but I just wanted to remind you that I had the very late distribution of the memo on election of officers. So we have to remember it's not on the agenda, that the hard copy agenda that you have, but it is an admin memo.
I'm reading the online agenda, and that would be memorandum 2020-41. Is that right, Brian?
Correct. So we can do.
Okay, that's on my list.
If you'd like. Yeah. Okay.
Let's just follow the electronic agenda.
All right.
Because I'm looking at that right on my iPad as we talk. And the next thing on the electronic agenda is the commissioner suggestions. This is the part of our meeting where commissioners are free to comment on proposals for study new topics or commission procedures or other general matters. Do we have any takers on that today? Okay. Mr. Rubin.
Before we go through that item and complete it, I'd like to hear a little bit of comment from Brian about Memorandum 2020-34, where you've included comment on some of the proposals that were made. Could we have some clarification of the conclusion that was reached? That would be helpful.
This is
I guess we're asking
commission authority to study real emergency topics.
Yes, please, Brian.
That's going to come up later in the agenda. So if it's all right, the chair has indicated he'd like to go through it in the order of the agenda items. So we for sure will dig into that heavily, but maybe not just yet.
Okay, I just wanted to be sure that I was following protocol by raising the issue now, but thank you.
Right, okay.
No, I appreciate that, Commissioner Rubin, and we'll have a discussion in general later in the agenda item before we actually dig into Memorandum 34.
Thank you very much, Chair.
Okay, thank you. Next item on the agenda, election of officers. This is my last meeting as the chair. It's Memorandum 2020-41.
Yes, thank you. And apologies again for the lateness of the distribution of this. As I said by email, when we went to monthly meetings rather than every other month, some of my annual reminders needed to be adjusted, and I didn't realize that need. So this is late, but it is important because, as the chair said, this is his last meeting within his term. If you decide you would rather have more time to think about it, we could take it up at the next meeting and ask the chair's graciousness in chairing that meeting until we get an opportunity to elect new officers. So it isn't absolutely necessary, but I put it before you, and if you're ready to elect officers today, that would be the best approach.
My suggestion, and this is just a suggestion, is that we put it off, and I'll just chair the meeting for 5 minutes next month before we turn it over, because next in the rotation is someone who doesn't seem to be present in this meeting, and certainly she should have the opportunity to be considered while she's on the Zoom call. Any
Okay.
objections to that possibility? I guess I'll be chair for 5 more minutes next month. Okay, very good. Turning next to the 2020 legislative program, the status report, please. Memorandum 2020-33.
So the status of our proposed legislation is much the same as I've been reporting at prior meetings. Our bills to recodify the Public Records Act was pulled some time ago for COVID-related reasons. The Senate Bill 1305, which would have implemented our revocable transfer on death deed recommendation, was mostly gutted for the same reason, although it still contains a 1-year sunset extension so that the RTOD deed statute won't lapse if we don't get a chance for our bill to be heard by next year. That, I understand, just passed out of the Assembly Judiciary Committee, I think yesterday. The resolution of authority, ACR 173, that's being carried by Assemblymember Gallagher is being heard today, and it's on consent. So I expect it will continue to move without trouble. The AB 1984 by Assemblymember Manchin is a collection of trial court restructuring reforms, and that's continuing to progress. So everything we have proposed that has survived the pruning that the legislature did to deal with COVID-related resource problems is continuing to move, and almost entirely on consent, if not entirely. So that's good. There is news to report that's not related. It's related to legislation affecting the commission, but not commission recommended legislation. And this was described in the first supplement to 2033. There is an Assembly Bill 1667 by Mr. Santiago that was introduced in 2019 to authorize electronic wills in California. That bill proceeded as a 2-year bill, I think in part because it ran into a lot of substantive objections. There were extensive negotiations and conversations with stakeholder groups like the Trust and Estate section of the bar, Judicial Council, Judges Association, with concerns of, I think, as is often the case when you're talking about estate planning, a lot of the concerns centered on fraud and mistake and authenticity. And as a result, the bill slowed down, became a 2-year bill, and then was just amended in the Senate before a hearing, I believe today, in Senate Judiciary. And the bill was amended to remove all of the language that would change the law to create and authorize electronic wills, and instead replace it with a section that would assign the commission a study of that topic with a due date of September 30, 2022. So if it's enacted this year, we would have nearly 2 years, a little bit more than a year and a half. It's a pretty significant topic. You can be creating a new estate planning device. There's a lot of detail in the resolution about the issues we would have to look at, and really realistically, that's what we would have done anyway, because you know, the most recent analogous thing that the commission did was the revocable transfer on death deed. And we did the same thing. We just marched through all of the issues that come up with any kind of estate planning device and figured out how to address them. So we'd have to do the same thing here. I think we're well situated to do this work. I think that our process and our familiarity with the subject is such that we could really bring people together and try to find whether there is common ground. There is a uniform act, I believe, on the topic, and we would be charged also with looking at that and considering its appropriateness as part of our study. We also would be charged with looking at the law in other states and other countries. So it would be quite a deep dive. One thing I say in the memo is that there's a nice bit of synergy here, which is that, you know, the commission is interested in doing emergency related work. That interest obviously prompted by the pandemic. The creating an ability for people to execute wills on their computers from home is a pandemic related reform. And moreover, the assignment language from the legislature specifically directs us to study the remote notarization and remote witnessing. And those are both issues that were in the first memo that we considered on whether to do work on pandemic related reforms. I see a look of confusion or thought on one commissioner's face. Are you concerned about why notarization, Diane? Yeah, I mean,
I just redid my will and it wasn't notarized.
Correct. That's right. The only thing I can think is that, you know, they might have thought that notarization in lieu of witnessing might be a possible execution formality we could consider. Normally wills are witnessed, not notarized. But I think this is a really timely for us because, you know, one of the things that we talked about early on was that a lot of people, when you're facing a public health disaster, a lot of people are thinking about their estate planning. And they maybe haven't before, and this focuses their attention and they want to deal with it. And then they realize, like, I don't want to have to go into Kinko's or pull two witnesses into my home and have them sit in physical proximity to while I sign. Or I'm in the hospital in an ICU. And I still have the capacity to execute a will, but I'm like under strict quarantine. How do I do that? So I think this is a nice, like I said, a nice bit of serendipity in that I think the general topic of estate planning is an excellent one for us to work on. But also this gives us a chance to be part of the solution for an important emergency related topic. There's no decision points in connection with this. This is information only. Because it's always our policy, the legislature can assign us whatever work they want us to do. And so I never push back if they're considering an assignment for us. It still has to be enacted, but I would be surprised if it's not enacted. The history that we have seen of bills that run into substantive difficulties and get converted into a commission study bill those are almost always enacted. It's usually part of a compromise. Does anyone have any questions about that? Yeah, Diana, see your hand?
I just want to let you know, because I do remain a uniform law commissioner by virtue of statute, I'm happy to connect you up with Ben Orzeski and the folks who would know about the Uniform Act.
And then maybe you could come to future commission meetings as a representative.
Well, we'll see about that. I love you all, but.
Okay, so anything else about that? All right. I think the only other thing I'll add is that this has implications for other matters on the agenda today. For example, if we're talking about emergency related work, we're only going to have so much bandwidth for that work. And we have Steve working as a contact tracer. We're doing the Common Interest Development Meeting Study, which is, as anticipated, ballooning. And now this is also going to be, although predominantly about estate planning, like I said, is also substantially an emergency related reform. So we may not have much additional capacity in that area, especially with everything else that's going on. All right, so that's it for the legislative program.
Okay, very good. I see we have more attendees now. So let recap something that happened before some people joined, is we decided to put off the election of officers to the beginning of the next meeting, but I'm actually open to electing officers at the end of this meeting if we have time, since we do seem to have most of the commissioners here present. But at any rate, we've skipped it for now. Moving on to emergency related reforms, and Commissioner Rubin wanted a more general discussion before we actually dig into the actual memo. So Brian, if you want to address the commissioner's inquiry about that he mentioned earlier.
Yeah. Well, you'll recall that at the last meeting we talked about this, and the suggestion was made, and it was the commission's decision that commissioners would be given an opportunity to informally share their own suggestions with me on what kinds of topics we might address as part of our work on emergency related law. And that happened. And some of you did share suggestions with me. They're summarized in the main memo, Memo 34. And then I thought it would be helpful in conjunction with considering those suggestions, if I were to go and take a look at what the legislature has done this year on COVID-related responses. Because, you know, everyone is burning the candle at both ends right now. And so I think we have to be strategic about what we choose to work on. And I don't want to step on anyone else's work. So I went and I looked at all the bills that mentioned COVID, either in the text or the legislative digest. That's not necessarily going to capture everything. It's conceivable that there might be bills that were intended to address the pandemic, but not expressly referencing it somehow. So that's a possibility. But I think that from the most part, the universe of bills I found is probably it. And there were about 125. A lot of them have died or been combined. And I wanted to look in particular at whether those bills address the subject areas that the commission was considering working on. And for the most part, they didn't. There were, of the topics that had been suggested, there were only really two that were addressed by pending legislation. One was in connection with our former work on the Tort Claims Act, now the Government Claims Act. So the sovereign immunity and this process for making tort claims against, or contract claims against the government, et cetera. There were a couple of bills there. They were both focused on the liability of schools. So bear that in mind. And then the other topic where most of the bills that overlapped addressed was employment. There were several employment-related bills. They're described briefly in the supplement. They're listed in the table that I attached. They address issues like special forms of leave, like the use of family medical leave for COVID, or a special grant of paid sick leave, or emergency leave. So that was one of the big centers of attention. Another was modification of workers' compensation. So, you know, workers' compensation is a system of providing you with wage replacement and medical benefit coverage if you're injured on the job. So those bills were intended to sort of apply the workers' compensation system to COVID-related illness, starting with a presumption that a COVID-related illness is a workplace injury, and then you know, fine-tuning and adjusting the existing law on workers' compensation for adaptation to an infectious disease. And then there were also, I'd say the third center was safety measures. There were a few bills that, you know, required the provision of PPE or required certain kinds of steps to keep employees safe. One thing that I noticed about those bills, and I think it's worth considering, is that the ones, especially the ones that touched on workers' compensation, which is imposes a cost on employers, and leave, paid leave, those bills were politically polarized in the legislature. There was a lot of support on one side, a lot of opposition on the other side. Some of these bills, as I said, I couldn't get an official roundup of support and opposition because they hadn't been heard yet in the form in which they're currently drafted. But I did go and look at the California Chamber of Commerce's 2020 top 10 job killer bill list. And these bills were well represented on that list. And that suggests to me that employers are quite concerned and would be pulling out all the stops, even if I can't cite to a committee analysis to confirm that there's deep employer group opposition. I think it's quite likely that any of those bills addressing workers' compensation or special forms of leave are going to be hard fought in the legislative process. So that's what I learned and reported. And so in that context, what the commissioners suggested was, I got a suggestion from Commissioner Simpson. He had, after looking through the prior memo, he sort of concurred with the staff that of the topics discussed in that memo, the ones identified by the staff as potentially relevant were the ones that he saw as potentially relevant. And those are listed in the bullet list on the first page of the main memo. Government liability, inverse condemnation, nonprofit corporations, administrative law, and tolling the statute of limitations. Then I also got a suggestion from Commissioner Carrillo that we effectively, if I understood it right, effectively codify the governor's executive orders allowing for public meetings to be conducted entirely by teleconference during an emergency.
That's basically right. And I noticed that we're already having to look at the impact of Bagley-Keene on something else later in the agenda. So, you know, it seemed to me to make sense to have a statutory authorization for this rather than having to tie it to, you know, the declaration of an emergency. You know, so it's something that, you know, because things happen county by county. So, you know, if you get a fire in LA, maybe the LA City Council needs to invoke statutory authority to meet remotely, and that doesn't have to be a statewide thing.
Commissioner Boyer-Vine, you have a hand up?
Yes, of the 3 COVID-related study committees from the Uniform Law Commission, there was only one recommendation currently for a drafting committee to be formed. It is precisely on that topic. So just so you know, there's probably a drafting committee being formed right now that's going to look at putting together a uniform or model law that states could adopt related to kind of these open meeting issues and how to do them remotely. But neither here nor there, just information for you to have in the future.
I mean, in part, I think the implication of that is that whether we work on it or not, somebody is giving it a hard look, and within perhaps the same time frame of what we would take to work on that, the ULC's Uniform Act will be available for California to consider. So I agree that I think it's a good topic for us if we have authority. We currently don't. I mean, that's part of that's the main gist of this memo is what issues do we want to request authority to study. It's possible that we could work on the Open Meeting Act narrowly just to codify the governor's order under our existing authority to study minor substantive defects. I think that would be a little bit of a stretch, but if we really wanted to jump into this quickly and turn something around quickly, we could maybe argue that that authority is sufficient. But if you're thinking instead about asking for a more firm and express grant of authority, that's going to take, that would require some period of next year before we'd have that authority. And so if Diane's suggesting ULC might have something next year, then perhaps we wait and see whether the Uniform Act is something that California wants to adopt.
Brian, how would you feel about, since both of those things look like they'll happen at around the same time, what would you think about including that request in our request for authority? And then by the time the ULC gets around to doing its thing, that's around the time that we would have that authority and actually have time to work on it. And then we could just take the off-the-shelf solution. So it kind of all happens at the same time.
Yeah, I don't want to get ahead too much in terms of like sort of forming a motion on the request for authority, but I think that's certainly a possibility that should be in the mix.
Yeah, and so what I really meant was let's not aggressively try to expand existing authority and run out and put a lot of work into this, because I realize the staff has a lot of other things going on, and so I'm thinking this is something that can happen down the road. But I anticipating that, I do think it's something we should include in our request for authority.
Yeah. Okay. Another suggestion was from Commissioner McAllister, who explained that she's had some difficulty working with clients who are incarcerated and being able to effectively meet with them. And when they're in county jails, in special facilities that they usually aren't in because they're trying to spread people out. And she thought maybe work on habeas corpus and bail to relieve pressure on the jails and prisons. I think those are all important topics. I think that one concern, and Jane, I think you mentioned this in your email to me, is that is more squarely in the jurisdiction of the Committee on Revision of the Penal Code. Although they're not working on either one of those topics this year, that is more their backyard. And then the other thing is just that although I didn't find statutes addressing these issues, I know there's massive work being done with CDCR and the administration and county sheriffs. There's a lot of attention being paid to trying to figure out how to relieve the pressures on the jails and prisons. And so, that may be an area where, at least in the initial emergency period, we might be duplicating others' efforts. And going forward, we might be stepping into a subject area where the committee would ultimately be working as well. So it doesn't preclude it, but those were my reactions to that idea.
Yes, I was going through, Commissioner King had asked us all to suggest a new topic to you at the last meeting. And so I was going through what we had previously been authorized to study, and one of those things was habeas corpus. And of course, there very well could be overlap. And I think we would need to wait and see what comes of a lot of the efforts that are being made. Most of the efforts are in relation to releasing inmates to prevent the spread of COVID, but there hasn't been much of any addressing, unless you're seeing that in what you've looked at, as far as the inability for clients or inmates, or whatever term you want to use, to have effective assistance of counsel, which is happening in many counties just simply by virtue of some facilities don't have the capability to have video conferencing. Sometimes what's happened in my specific case that I'm talking about is a client of mine has been moved to a safer location, which is great, but he is unable to contact us to prepare for his trial next month other than by phone, which is impossible. And they're really, really tight for good reason. We were prohibited from accessing the detention centers, which is smart. And really, it's perilous to go now. It's really not a good idea. So I just threw that out there because I think it's something that's going to come up. I mean, it's something that's kind of a perennial topic depending on where you are, because it happens not just in a COVID-related sense, but definitely in a COVID-related sense. So I'm not saying we have to study it right this minute or you should ask for it, but I do think since apparently we have previous authorization, it is something to keep in mind. And I definitely don't want to overlap with the committee. So if that's something they take up, fantastic.
Okay. And then the final suggestion was from Commissioner Rubin. His suggestion was that we look at and work on employment law to sort of try to address the significant pressures that are being placed on employers and employees in terms of costs and safety, et cetera. So my bottom line on this, and then I'll step back and let you all talk about it. I suggested, I think in the main memo, that there are a couple of ways you could proceed here. One is you could cherry pick particular topics and ask for specific authority on that. The other is that, I suggested the language, I think in the supplement. Yeah, in the first supplement, at the bottom of page 6, I suggested the possibility of requesting a broad grant of authority, subject to a requirement that we consult with the legislature before commencing work. The idea being, if we cherry pick topics, I think one of the concerns I have is that we're going to create expectations that we're going to be able to work on them. I mean, we've run into that problem in the past with requesting authority to work on a topic and then never having the resources to actually do it, especially if we were going to reach back to sort of moribund topics like inverse condemnation, right? Or administrative law, where we really haven't done any work recently. And if we ask for authority on that, then I think the legislature is going to be looking for us to activate it. So I think they were identified as potentially relevant, but I don't know that we actually would be in a position to do anything about them. So that's what prompted me to think it might make sense to be a little more diffuse, ask for a broad grant of emergency related work subject to this consultation requirement, and then we address it annually through the new topics process. So we can look at what resources do we have, what new work should we prioritize, et cetera. That's all I have to say on it, just as a possible alternative to requesting specific grants.
Brian, since we have some new commissioners, you want in a sentence to summarize what is this process. I believe it usually happens September, October.
Yep, it usually happens in September or October, usually October. And you will be seeing a memo at the next meeting or the one after on new topics and priorities. And typically what we do there is we reiterate all of the commission's existing authority, all of its existing work. We lay out how much of our staff resources are being consumed by the existing work. We discuss proposed new topics, and we get a lot of suggestions from the public, from stakeholder groups, or from individual commissioners. And then to the extent that the commission has any slack in its resources, it can choose to activate a new study. And then from that point going forward, we'll work on that. Traditionally, we have followed a particular priority scheme where we prioritize work on projects that were specifically assigned to us by the legislature over projects that the commission itself generated. So for example, if we get this new study on electronic wills, that would have priority. We'd make space for it. We also particularly prioritize legislative assignments that have a deadline. If there's no deadline, then we can take a little bit more time. If there's a deadline, we have to meet it. And again, the electronic wills assignment has a fixed deadline. So that's another reason why that would be a priority. Then we also try to prioritize existing work. So if we've got a study in progress, we'd like to finish it before starting new work. That doesn't necessarily preclude starting new work, but it just means in assessing like the adequacy of our resources and our obligations, we have traditionally prioritized putting resources into active studies, already active studies, over starting new ones. And then below that tier, we also prioritize, it's not an issue right now, but we also prioritize studies where we have a consultant's report that was prepared for us on a particular topic and we don't want it to go stale. So we try to complete those projects too, with a little bit higher priority. So that's all going to be presented to you in a memo, and we'll have a conversation at that time where we all collectively get on the same page in terms of understanding what we can do, what we are doing, and what we should do in the next year.
All right, very good. Commissioner Rubin?
Thank you. Well, first I want to thank staff for going to the effort of giving us a comprehensive report based on our deliberations at the last meeting. I was encouraged by the fact, and I hope other commissioners are, that the legislature asked us to respond with suggestions. We did not initiate that motion. It was initiated by the legislature. So I think we should keep that in mind, because that kind of presented the framework that in which we're having this discussion. When I brought up this issue, which I did at the last meeting, it was looking at the fact that the immediacy of the emergency is now. I don't want to make a Yogi Berra kind of comment about that, but the fact is we are looking at the need, if we're going to recognize that need, to take some kinds of action now with regard to any of these studies, which could subsequently not have the same relevance that they would at this point. Obviously, that is because of the fact that the ongoing pandemic is creating issues that we are addressing, the state is addressing, we are all addressing as we proceed. And I think it's recognized that there are areas which we could look at, which would invite a more active response if we were to determine it was within our authority to offer one. I think I'm satisfied, and perhaps other commissioners are as well, that we have the authority already in place, which we discussed at the last meeting, to make the suggestions that are being made today. I don't believe we have to ask for any expansion of our authority. I am not of that opinion that that would be necessary. My concern goes to the fact that in looking at the bills that have been examined before the legislature, that is our collective opinion that they encompass a sufficient number of areas and actions that we feel require no further response on our part. Now, I believe we are constricted by the fact that we are not an organization or a body of the state put together to act as advocates for any particular points of view. And having said that, I know that some of these areas, as Brian has appropriately pointed out, are very politically sensitive. And I don't believe we should get involved in those areas at all, because they bring us into a domain that can cause us issues and difficulties we don't need to address. I secondly understand that there are restraints upon what we can take on, given the limitations upon staff time and resources. And it is probably not the right time to be entertaining ideas that would engage staff in activities that are excessive in nature in terms of what would have to be done. So I do understand all of those things. I guess my concern is that we look at, and there are some issues that have already been presented by other commissioners, and I think they're good ones that have been brought up. I would propose that this discussion remain open so that when we come back in September and beyond, we would see in retrospect whether we have in our own minds taken the necessary actions within our authority to respond to what the legislature has asked us to do. And I think in doing it in that fashion, we are not taking upon ourselves anything that we're not permitted to do. So I think those are the ground rules that I see us following. I gather from the last remarks that you made, Brian, that we're going to be looking at prioritization in the future, which would presumably include studies that have not or will not come up in today's discussion, and which might be subsequently recommended by members of the commission. And I think that's fine. I think by leaving ourselves that latitude, we have not foreclosed the possibility that we might come up with ideas that we want to see further pursued. So I'm of the opinion that as things now stand, there are going to be significant problems that will be incurred in the workplace, which will require employers and employees to give very considerable examination of the regulations and rules under which they are currently operating. And a lot of those obviously are going to have to be privately created, modified, authorized, and adopted. That's not our job. Having said that, as a commission that is conscious of the exigencies of the moment, and they are considerable, we should not relieve ourselves of whatever obligation we think appropriate to look at ways we can take remedial action if it's within our power to do so, and in our interest in doing so, to further mitigate some of those consequences. So that is really where I came out on all this. I think this is a very healthy discussion, and have this discussion. We are probably at a point where we should have a consideration of a resolution that we could make today, if that's appropriate, which would enable us to keep this open as an open matter for further discussion later on. And I guess that's up to the commission to make that decision. But I don't want to see us exclude from future consideration some ideas that we are not talking about today, and foreclose the opportunity to look at this again as we should in the immediate future. And again, I point out that it's the immediacy of the problems which causes us to have this discussion at all. A year before now, we wouldn't be even having this conversation. It's happening because we were asked to have it. And I'm just hopeful that the commission is willing to be responsive to the offer that has been made to us to come back with ideas that fall within our purview or which we think should be within our purview. So I won't belabor this any further, Chairman King and others, but I did want to put this on the table and hope that the resolution, which is still on the table from our last meeting, is large enough, wide enough to cover the issues that we're talking about today and any future issues. I guess that's pretty much where I come out of this, and I hope I've not done a terribly bad job of summarizing my thoughts. Thank you. That's all I wanted to say.
Commissioner Rubin, thank you for those very helpful suggestions. I'm not in any way opposing what you're suggesting. I'm asking the question though, do we need a separate resolution today for that? in that we do have, as a continuing part of our agenda, a specific item at every meeting where commissioners are allowed to make suggestions. I understand your input that you would like more of a focus on emergency COVID-related suggestions, but I'm just positing or questioning whether or not that's already taken care of by the larger agenda item of having commissioner suggestions. It'll be implicit, and every meeting from now on, we can certainly discuss in that agenda item commissioner suggestions in general, as well as emergency COVID-related suggestions. Or do you think there's a need for a separate agenda item? I'm just trying to parse out what you're requesting.
I take your point on that, and I think my feeling is that it would be helpful if we were on record as suggesting that in relation to COVID-related issues, we reserve the possibility and resolve that we will look at those issues specifically as they come up, rather than to leave it as part of a generalized response that we're making. I looked at the resolution, I don't have it in front of me, which was on the table. I guess we didn't act upon that resolution because we were going to have this discussion today. And I don't have it in front of me. Maybe Brian, you could pull it back and remind us of what it said in there. And let's decide today whether or not it is sufficient within itself without further modification. Is that a fair idea, Chair?
I'm certainly open to that. From what you're saying, it sounds like at some point we need to have a formal motion and a second and a vote on this. So my concern would be, what exactly would the form of that motion be, and are you prepared, as you're the main proponent, to vocalize that?
Yeah, I
right
wasn't
now?
going to attempt to try to actually stylize that motion because I think it's not my duty to do that, but I think the commission would be helped by the fact that we had such a resolution, which we would then have the legislature hear us make, to have it understand that we've been responsive to their request, that we come up with ideas that they might want to further entertain. And I don't know how to formulate that. I'm not going to try to do that on the run, but I would like to have us have that resolution in place and made so that we specifically have responded to a request by the legislature to react to their request, that we make suggestions as they regard specifically the pandemic emergency, and that we're looking at this as a long-term proposition which could change over a period of time, given the fact that we don't really know yet all the consequences of this emergency. So I'm using a lot of words to say something which is, I suppose I could try to formulate more simply, but I haven't really put it into words, and I apologize for that.
Okay, so we're not going to necessarily be prepared to pass that today. Certainly something that we can discuss at our next meeting. And meanwhile, Brian, you can give some thought as to how formal a response we need to give to this legislative suggestion that we look at emergency-related things. Do we need something as formal as a resolution, or could we just instruct you as the executive director to acknowledge it in some sort of letter or something like that, as opposed to a voted upon resolution?
I think there might be some confusion, and I apologize if it came from my memo, but I don't know of any request from the legislature that we make suggestions to them for reforms. My recollection and understanding is that this discussion is part of a discussion that the commission started for itself to consider ways in which it could generate helpful recommendations without having been specifically requested by the legislature to do that work. And we looked first at what existing study authority we have and how COVID-related reform work could be conducted under that existing authority. And then the next piece was to consider whether we wanted to request additional authority to work on COVID-related topics that aren't currently authorized for us. So, for example, this idea of looking at electronic wills that will be specifically authorized and mandated by statute. We wouldn't need any other authority for that. If we wanted to look at the use of electronic notarization of powers of attorney, that would not necessarily be contained within this new bill, but it would be covered by our existing grant of authority to study anything in the probate code. So we already have significant baseline authority that we could use to examine emergency-related statutory reforms. That's the subject in the next memo. See, we're the common interest developments. We have authority to work on common interest developments already, so we can do COVID-related work within that grant. The question that I understood today's memo to present was whether, and if so, how, the commission would want to ask the legislature for expanded authority for COVID-related reforms. And the two possibilities that are discussed here is, one, we could cherry pick specific topics like Open Meeting Act practices. We request authority to work on the Open Meeting Act in connection with emergency-related law. We could do that. Or we could do something broader along the lines of what I proposed on page 6 of the supplement, which would give us sort of maximal flexibility as to subject matter, constrained by getting a reality check from legislative staff so that they could let us know, like, no, we already have a bill on that issue that's in the works. You don't need to look at that. Or, yeah, that would be great. You know, that's something that we aren't looking at now and it'd be useful. So the language at the bottom of page 6 reads, the Law Revision Commission is authorized to study and recommend statutory reforms to provide special rules that would apply only in a period of declared emergency or its immediate aftermath. Before beginning a study under this authority, the Commission would provide notice to any legislative policy committee with jurisdiction over the proposed study topic and would consider any formal or informal feedback received from committee members or staff. So, like I said, maximal flexibility as to subject, constrained by the fact that it would have to be emergency-related reforms, and then a requirement that we consult with the committees that have jurisdiction to see whether they think that would be a good use of our resources. I see a hand, Commissioner Simpson.
Yeah, I was actually looking at that language as well. I think that looks fine. I would, if the commission was inclined to go that direction, I might suggest one little modification to say, provide notice to legislative leadership and any legislative policy committee, blah, blah, blah. Because you will, as a practical matter, you will tend to find that the policy staff in the speaker's office and the pro tem's office may well know more about what's going on in a policy area than the committee does. So just a techie thing.
David Carrillo.
I'm also on board with what Commissioner Simpson just articulated. And I'm wondering if now is a good time to advance this by considering a motion to adopt that language that we just discussed.
Well, I would offer one more slight tweak based on something you said earlier in the meeting, which is it might be important to recognize that this would encompass both declared state emergencies and local emergencies. I mean, because it might be that, yes, fix Bagley-Keene, that's a state emergency, but fix the Brown Act in case it's constrained to a particular county or something. Commissioner
Totally
Boyle?
agree.
Well, there is an Emergency Services Act that
I'm very familiar with that.
Yeah, we might be familiar with some issues in common, David. I think they, you know, I don't know if you want to be that specific and tie it to those acts. One deals with local emergencies, the other deals with the state emergency.
Right.
I mean, neither is entirely effective in a pandemic that goes on and on and on, and that's a big issue, but that's for another day.
Yeah, and actually we do have specific references to that law in the CID proposed language that's in the next topic, agenda topic. So I think that's a good idea. It might make sense to tighten it because then you've got a bright line rule.
Can I just interject? Do any audience members have anything to say on the commission's authority or this topic? If you do, please raise your hand. I see no takers on that.
Well, hold
Okay,
on.
how do you like to proceed on this, Brian?
Yeah. Well, I'd be interested to know whether there's a motion and a vote in support of this language revised along the lines we've discussed. And I think, Commissioner Rubin, this would have to go before the legislature and they would vote on it. So I think it would constitute a clear signal to them that we're offering to help, and a signal back from them on whether they want us to.
I'm happy to go along with what you suggested, and I'll be happy to make that motion.
Okay.
I don't know what the words are that you're going to use to make it, but
I was going to move that we adopt the language on the bottom of page 6.
But there are some modifications though.
With the modification.
we have the modifications to be made.
Legislative leadership included within the consultation language, and references to the Emergency Services Act on declared state emergencies and declared local emergencies.
That's my motion.
Okay, that's the motion, page 6 with the 2 adoptions. Commissioner Bourdain.
Are there not federally declared emergencies too that we want to consider those?
Yep, you're
I mean,
right.
do we need to specify? Can we just go with a general umbrella term, emergency?
Well, that's an issue we're about to talk about in connection with CIDs. I think the greater specificity is helpful, because otherwise, how do you know as a matter of law whether you're in an emergency or not?
You could always link it to the ESA, which does have a definition.
Yeah, I mean, if you link it to the,
yeah, but I mean, I think, sorry?
I think you should look at the ESA. I mean, we can pull it up. It might talk about federal emergencies. I just didn't want to leave out that concept.
Right. Okay.
Commissioner Miller Ryan, I see you gesturing.
Oh, no, I was doing, but I think, and also too, David, we don't want it to be too general. These meetings are public and they're for, everyone. So emergency, without linking it specifically to this memo or just federal or state acts, it would create more confusion than would be intended. So the unintended consequence of trying to be general will hurt us probably more.
Okay.
Does anyone want to
hear a vote on that?
You have a motion on the floor. Do you need a second for that motion?
Yeah, I need a second.
We do.
I'll give you my 2nd.
I'll second it. Yeah, I'll second it.
Okay. Any other discussion among commissioners? And I see no audience request for participation either. Okay, with the motion and the second, all those in favor, raise your hand and say aye. Aye. And anyone opposed, now raise your hand and say no. Seeing none and no abstentions. Very good. Brian, have we covered everything under Memorandum 34? Do we need to do some more?
We have, yes.
Very good. I will now turn to Memorandum 35 on Common Interest Development Meetings.
Okay. So this is the second study we've undertaken to address emergency related reforms. The first was the sunset dates, and that's been completed. This is the idea that we would extend the teleconferencing flexibility that the governor created for public body meetings to common interest developments. The main memo, 2020-35, proposes some language, and I think that it might be appropriate to just focus in on details at this point and work our way through them, because we've had general conversations before, and I think the commission has generally been interested in working on this topic. So I don't know that I need to recap some of the bigger picture questions. Instead, I think it'd be helpful to work through the specific decision points, and I fully expect there's going to be public comment on this. We've got 2 supplements before you today that have comment letters from stakeholder groups and individuals. And I received another letter last night that I wasn't able to turn around for you today. And I expect, you know, as I've said before, the Commission's experience with working in CIDs generally is that it's kind of like drinking from a fire hose. There's a lot of pressure for reform. And some of the letters that we've received aren't before you today because they don't talk about the specific issue of teleconferences during emergencies. They're just people telling us the things they want to change about CID law. So we're going to present those as part of the new topics memo when that memo comes around in September or October, because they're really beyond the four corners of the specific study that we're conducting today. So the idea that I described is expressed in statutory language at the bottom of page 3 of the main memorandum. And there are a couple of overarching points to discuss before we get into the specifics. And then once we're into the specifics, I think I'm just going to march through each provision of the proposed legislation, and we can talk about the policy decision and any issues with the language, and we can consider comments on that specific issue. So my hope is that we can hear comment from the interested people sort of incrementally as we move through each of the issues. I think it would be harder if we said, all right, now let's hear from this person and they're going to tell us their positions on all the different 8 issues, and now this person and their positions on all the different issues. So my hope is that the commenters will be amenable to that approach, and that we can just interleave their input as we move through. The first issue has to do with whether we ought to do this at all. This is one of the overarching issues. We have a letter from Mr. Peterborg, who's present in the audience, that we received. I distributed it yesterday, I think, so you may or may not have had a chance to read it. I would say that his principal concern, and this was also expressed in the letter I received last night from Marjorie Murray on behalf of the organization she works with. The concern is about whether or not we're assuming too much in assuming that people throughout the state are going to have adequate access to the internet or cell phones or adequate technical familiarity with those tools to be able to participate if the meeting is held by teleconference. Now, one of the issues that's going to be part of our detailed survey of the issues that's going to come up later is that we are in this language recommending that if a CID does hold a meeting by teleconference, that it be required to permit member access by telephone. And that specifically was intended to address the fact that some people won't have internet access or won't feel comfortable using an internet-based interface, but everyone should be able to listen by phone. It's not ideal, you can't see people's faces, etc. But it is a way to hear the proceedings and speak. We've had people speak in our meetings by telephone. The letter we received last night from Ms. Murray points out that using a landline telephone may result in a person incurring tolls. However, I do note that at least with respect to Zoom, which we use, they always provide toll-free numbers that people can call in on at no cost to us. It's just part of the package of services. And the other thing to realize about this is that we're not, at least not yet, suggesting that these be the rules always and for every meeting. We're talking about making these the rules for meeting during an emergency. And so I think we don't want the perfect to be the enemy of the good. What we're trying to do is find a way for these organizations to be able to continue to function when they cannot hold meetings in person because of an emergency. And so we can try our best to make it as inclusive and protective of the rights of members as possible, but the possibility that not every member who wants to participate will be able to because their internet is down, or they don't have a landline and their cell phone reception is poor, etc. Those are legitimate concerns, but I think they have to be balanced against the possibility that an association might not be able to meet at all if it has to abide by the existing requirement that it have a physical location for the meeting. That would have been the truth for us if the governor hadn't waived the Open Meeting Act requirement of a physical anchor for the meeting. We wouldn't have been able to meet for the last how many months it's been since February. And so, and in fact, I think in some ways our meetings have been better attended on Zoom than they were in person because it's easier for people all over the state to participate. So that's my introduction of the first issue up for decision, which is, at least for the purposes of a tentative recommendation, do you want to proceed with the development of this proposal?
Anyone?
I'm fine with it. In particular, I'm on board with the narrow recommendations rather than the broader ones.
Commissioner
And
Simpson.
Brian, you used one of my favorite phrases, don't let the perfect be the enemy of the good. I love it.
Commissioner Simpson.
Yeah, I had the same inclination as David to move forward, but in a very narrow sense. The only thing I will confess, I don't know much about common interest developments and what are the consequences of them not being able to meet at all. I mean, I get it from a public body who has, you know, regulatory or adjudicatory responsibilities. I mean, is that a big deal if a common interest development can't meet?
Yeah, it's the body that maintains the property that is commonly owned by all the members. So for example, if there need to be emergency expenditures to deal with a pandemic, you know, they're gonna have to spend some money that's not in their budget to take safety precautions. They would need to be able to meet to authorize that. Or, you know, to figure out what to do if there's been a fire and, you know, some of the structures are destroyed and how we're going to handle this. That's going to be the board that has that responsibility, as informed by the membership. I mean, these board meetings are open to their members, but they do, I think, it's conceivable that they'll be making emergency related decisions.
Okay, no, that helps. Thank you.
Yeah. I see a hand, Victor, from Commissioner Boyer-Vine.
Yeah, go ahead, Diane.
Well, just to answer Rick's question, having been the only commissioner here who lived through all of the CID discussions previously, they do operate, Rick, like municipalities with, you know, they have authority to put liens on homes if people are out of compliance. And so there are some real significant issues they take on for homeowners in a common interest development area.
Got it.
So I'm supportive of this. You're missing a period in one of your drafts here, but I'll get there.
No, I'm attributing that to you because you said you were supportive of the proposal. So any commissioner inclined to drop this? Okay. I mean, I think it's important to note that this will proceed to a tentative recommendation. And so at that point, we'll have a fully fleshed out proposal and we'll distribute it for public comment. So there's no guarantee that the decision to proceed today means we will proceed through to a final recommendation. It's possible we would decide to table it. Okay, so the next issue I think is technical, almost not worth mentioning, which is the proposal of the staff to locate this as its own separate section in an article on emergency powers and procedures rather than trying to shoehorn it into the existing rules on meetings. We've got a comment from Elaine Roberts-Musser supporting that. Nobody else commented on it. I think it makes sense. It's nice to have a container for related provisions, if any are needed in the future, they could be located in the same place. Is that all right?
Yeah.
Hearing no opposition, I'll take that as assent. And I'm keeping an eye on the attendees. And so I saw a hand go up and come down again. If anybody wants to be recognized, I'll try to notice that and call it out to the chair's attention. Okay, the next issue has to do with the scope of application. And this is the language in 5450A. This section only applies to a common interest development that is in an area affected by one or more of the following conditions: a state of emergency proclaimed under section 8625 of the Government Code, a local emergency proclaimed under section 8630 of the Government Code, a state of disaster or emergency declared by the federal government. We got a couple of technical suggestions from Elaine Roberts-Musser on this. She thought, since it says CID law to an unusual degree is law read by lay people, it might be helpful to add a little bit of language to say, for example, a state of emergency proclaimed by the governor, a local emergency proclaimed by whatever the term of art is for the local public entity that declares such an emergency. Just to make it a little easier for people to see what the contours of the bright line and understand whether they're within it or not. And then she also suggested reordering the provisions so that they sort of go in descending order of scale. So federal, state, local. I mean, it's a nicety, but I don't see a problem with it. So okay with some technical tweaks along those lines?
Everyone okay? Looks like it's so, Brian.
Okay.
Yeah, I don't mind reordering them. Although being a California guy, I hesitate to put the federal government at the top of the list. But
that was my thinking too.
Yeah, but that's trivial. But the actual substantive issue that I do have is swapping. Is the proposal to swap out the references to the government code sections and replace them with okay? Because I specifically want that in there. I think that's important. Because if the governor's incapacitated, then whoever's next in line of succession could be the person actually invoking that statutory authority. So I don't want to tie it to the title.
Oh, you don't want to include titles?
No, I'm fine with including it. I just don't want that to be the only thing.
Got it. Got it. Okay.
Because if Gavin gets killed, then somebody else has to actually invoke the government code's authority. So
right.
Like it might not actually be the governor.
Right. Got it. So the next, we're starting now to get into the issues where I'm expecting some comment.
And before we get to that, I should have said this at the beginning of the meeting. This meeting is being recorded. The Zoom meetings have been put on YouTube. So I just want to let the audience members know that.
Yeah. So the subdivision B is the sort of the meat of the provision. It authorizes the use of teleconferencing without a fixed location, provided that certain standards are met. And the standards are there to, you know, the without the physical location element is the key to making it an emergency teleconference. The standards are there to make sure that nobody's prejudiced by, to the extent that we can foreclose it, that everybody's rights to participate are protected. So the first one is paragraph 1. The meeting notice provides clear technical instructions on how to participate by teleconference. We got supportive comments for that. Nobody is opposed to that. I don't see it. I got an email from Marjorie saying she's trying to be recognized. I will see what I can do.
Or if we need her to just telephone in, Brian.
No, I've just permitted you to speak, Marjorie, but I think you maybe have more than one device on because we're getting terrible feedback.
Yeah,